Good evening. I want to begin by thanking the HIV Legal Services Fund of the American Bar Association HIV AIDS Impact Project. Your generous funds make it possible to bring us this training to you today. I'm Fyra McCandless, and I will do this intro. Here is our brief agenda for the training. I will begin with a quick introduction and overview of ALRP. I will then introduce our presenters who will provide the substantive training. We'll save some time for questions at the end and wrap up no later than 7:30 Pacific time. Quickly for some housekeeping. You should have received the materials in an email from mcle@alrp.org. Send me a message in the chat if you have not yet received them. If there's another email you would prefer that I send it to, you can send that to me in a private chat message now. We will reserve time at the end of the training for questions. ALRP is a certified MCLE provider in the state of California, so we're glad to provide 1.5 hours of general CLE credit to California attorneys joining us today. I hope that you will take the time to complete our brief evaluation at the end of the training. It should appear in your browser when you exit Zoom and will also be linked in the follow-up email tomorrow. Evaluations are required for those of you seeking CLE credit. I will email you your certificate once I have received an evaluation from you. We will be recording this training and sharing it as a resource for anyone interested. ALRP also has other trainings on offer this year. Here is our list of upcoming trainings. We're thrilled to be sharing this training with individuals and organizations across the country. Before we get started, I wanted to spend some time introducing ALRP to those of you that may not be familiar with our organization and the work that we do. ALRP was founded in 1983 in response to the AIDS epidemic. At that time, ALRP was simply for attorneys who were drafting wills and durable powers of attorney for those who were dying of AIDS. Drafting legal documents such as these allowed individuals to die with dignity and fulfill their wishes about healthcare and disposition of assets. As treatments have evolved, so too has ALRP. Since 1983, ALRP has handled over 80,000 legal matters for our clients. We are somewhat unique in our provision of legal services in that we offer direct services in-house with our staff of 12 attorneys, in addition to operating as a lawyer referral panel. Maintaining a very large and diverse community of volunteer attorneys, our staff and panel of several hundred volunteer attorneys help our clients in a variety of legal areas, including immigration, housing, employment, credit, insurance, family law, confidentiality, and government benefits. Our goal in offering these trainings is twofold. First, we hope to increase the capacity of the attorneys on our panel and other organizations providing legal services to people living with HIV/AIDS. Second, we hope to recruit new talent to join our panel and help us to meet the legal needs of people living with HIV/AIDS in the San Francisco Bay Area. If you are a local attorney that is not yet on the panel, I hope you will consider joining our ranks. As an attorney on our panel, you play a key role in helping us to provide low-cost legal counseling and representation to our clients. We ask the panel attorneys accept 2 referrals a year and tailor the experience to your experience and availability. ALRP conducts a thorough intake in order to make an informed referral and then provides a warm handoff. Once the client has been referred to you, the case is yours. Just a few of the benefits of serving on our panel include free MCLE trainings, mentoring, malpractice insurance, and networking opportunities. If you aren't already a member and are interested in joining our panel or have any questions, please reach out. Our contact information is on the slide now. Without further ado, I would like to introduce our presenters for this evening, Jose Marin and Jhon Tesoro. Jose is licensed to practice in the state of California and is admitted to the United States Courts of Appeals for the 9th and 5th Circuits. He graduated from the University of California, Berkeley in 2008 with a bachelor's degree in political science and obtained his Juris Doctor degree from the University of San Francisco School of Law, go Dons, in 2013. Jose served in the United States Marine Corps for close to 10 years. He was meritoriously promoted ahead of his peers and received multiple service awards, including a 5th Gold Star in lieu of his 5th award of the Navy and Marine Corps Achievement Medal. During law school, Jose worked in both the public interest sector and private practice. He provided pro bono legal services at the nonprofit Bay Area Legal Aid in their San Rafael and Richmond offices and worked at the firm Mallison and Martinez on issues involving complex litigation, class action lawsuits, unlawful discrimination, and wage and hour claims. Jose provides legal services in areas of immigration and employment law in different forums, including administrative, state, and federal court. He's a member of the American Immigration Lawyers Association. Jose has volunteered as an advocate at La Raza Centro Legal in the Workers' Rights Program in San Francisco. Jose has been on our panel since 2015. Jhon Tesoro is an immigration and civil litigation attorney, recently back in private solo practice after serving as an assistant chief counsel for the Department of Homeland Security. 5 years before working in government, Jhon worked in various immigration law firms in the Bay Area, primarily representing respondents in immigration court and preparing applications for collateral relief with the USCIS. Jhon has been on our panel since 2018. Please join me in giving Jose and Jhon a warm virtual welcome. So you can go ahead and share your
thanks.
slides.
Okay, well, hello there, and thank you for joining us today. We're going to get started with provisional waivers. Jhon, if you could go to the next slide, please. So as we know, we are lawyers here, most of us, I believe, and so we have to make sure that we do our little disclaimer. Remember that this is not to be considered legal advice. There are limitations to the class. It's very broad and general. So if you have a specific case that you need help with, please be sure to do further research on your own. And if you're not a lawyer, I will advise you to get one, to get advice so that you can properly represent your client or properly, prepare the packet for the provisional waiver. Next slide. So there are two main sources of law in the provisional waivers. I'm going to direct you to the Immigration and Nationality Act, the INA, Section 212A9BV, and the Code of Federal Regulations, 8 CFR, Section 212.7. As you may already know, the Constitution also applies, and also presidential case law. And but these are the two provisions that you will need to pay close attention to when you're preparing your packet or your provisional waiver for your client. You must always keep in mind what the requirements are under the law, and those are the two provisions, again, that you need to pay close attention to. Next slide, please. So before we get started, we have to go over the inadmissibility grounds. Just so that we are clear, a provisional waiver is a waiver for the inadmissibility grounds. And the one that we're going to be doing specifically today is for unlawful presence. But let's go over what inadmissibility grounds are first. So in order for anyone to immigrate or to come to the US, they have to have a visa. There are exceptions to that. You can be paroled, and there are other ways to come in, but generally it's through a visa, and the visa can be for an immigrant or non-immigrant. Regardless of whether it's for an immigrant or non-immigrant, the inadmissibility grounds apply. What are the inadmissibility grounds? There are basically things that would disqualify that person from obtaining a visa. And you can find those in the INA as well, Section 212, Section 212 of the INA, the Immigration and Nationality Act. And you're gonna hear me saying INA, and when I say INA, I mean the Immigration and Nationality Act. So what the provisional waiver is a very specific waiver that only covers one inadmissibility ground. There are multiple inadmissibility grounds that relate to crimes or security-related grounds, some that relate to health and various others. But the one specifically for the class today is for unlawful presence, as I mentioned earlier. So as you can see in the slide, when a person applies for an immigrant or non-immigrant visa, they have to go over the inadmissibility grounds, and we have to make sure that when you are screening your client for the provisional waiver, that you identify specifically what inadmissibility ground we're talking about. If when you go over the inadmissibility grounds, if that person is inadmissible for any other reason other than unlawful presence, then they don't qualify for the inadmissibility for the provisional waiver. The provisional waiver, again, is only for one specific type of inadmissibility ground. You don't want to miss any inadmissibility grounds, because even if you get this approved and eventually they keep going through the process and they discover that there are other grounds that apply, the inadmissibility ground waiver, the provisional waiver, is automatically revoked and they have to start all over, and it's more problematic. Anyway, so the inadmissibility ground that we're talking about is unlawful presence, and the specific language in the statute says any non-citizen. The statute itself actually says alien, but for the most part, immigration lawyers, we don't use that term. We use the term non-citizen. And even the Supreme Court in recent immigration cases, they don't refer to people as aliens anymore. I believe that Congress probably will have to update the language just to match the court's definition. Anyway, it says any non-citizen who was unlawfully present in the United States for a period of more than 180 days, but less than a year, voluntarily departed the United States and seeks admission within 3 years of such departure or removal, or any non-citizen who has been unlawfully present in the US for 1 year or more, and who seeks admission within 10 years of the date of such non-citizen's departure or removal from the United States, is inadmissible. So as you can tell, there are two periods of time that have to occur for someone to be inadmissible. They either have to be here for 180 days or more, or a year or more. And this is what usually immigration lawyers refer to as the 3 and 10 year bar. So the statute says that those people who are unlawfully present for those periods of times are inadmissible. And you can see again, section 212A9, BI of the INA. Next slide, please. So before we get into it further, we have to get some concepts in pre-screening. So what's unlawfully present? The INA does not have a definition what unlawfully present is, but the statute reads as follows: a non-citizen is unlawfully present if the non-citizen is present in the United States, physically present in the United States, after the expiration of the period of stay authorized, or is present in the United States without being admitted or paroled. Let's break that down. Unlawfully present means that you might have entered the United States with permission, but the moment that you stay after that period, the unlawful presence begins to run, to accrue. It's and it also applies, for example, when somebody enters the United States without having been admitted or paroled, meaning that they were not checked physically by an immigration officer before entering the US. So those people, the moment they set up foot in the United States, they start accumulating lawful presence. And somebody that, for example, enters with a visitor's visa or a tourist visa, they call, then they start accumulating that lawful presence after the period of authorized stay expires. What is that period? It depends. Most of the times, I've never seen it otherwise, but I imagine that immigration officers may have authority to grant a lesser period. It's usually 180 days. It matches the statute. So from that moment, they start to accrue lawful presence. Again, once they accrue 180 days after the period, then they become barred by the 3-year bar. And if they stay over a year, then they trigger the 10-year bar, they call it. Inadmissible. Again, there is no definition for the word inadmissible either in the INA. What the word that they have is admitted or admission. So I suppose we can read the statute for that specific definition and see what that means. It says, with respect to a non-citizen, the lawful entry of the non-citizen into the United States after inspection and authorization by an immigration officer. And you can find that in section 101A13 of the INA. The term in as a prefix means not, none. So inadmissible means somebody that was not admitted or who had an admission to the United States. So again, that could be someone that entered without permission, somebody that crossed the border without speaking to an immigration officer, or somebody that overstayed their visa. Next slide. So not all unlawful presence is created equal, and there are some exceptions to it. So when you're screening your client for the unlawful presence, for this inadmissibility ground, you have to keep in mind that there are exceptions. You have to go to the statute. Always go to the statute. There are times when USCIS or some other agencies may not actually be following the specific language in the statute, and your job is to make sure that they not only to help your client represent them, but also to make sure the government is applying the law correctly. So one of the exceptions to unlawful presence is minors. So I want to give an example. Somebody from a Central American country comes to the US and they bring a child with them. The child is under the age of 18 and they enter without being inspected or admitted. Remember, not being inspected, admitted or parole means that they didn't speak to an immigration officer or they entered before requesting permission to enter the US. So parents bring a child, the child is the age of 2, the child stays here for say 10 years and then departs the United States. Did that child accumulate lawful presence? No. They don't accumulate a lawful presence when they're minors. They have to be adults. What is a minor? There's also a definition for minors under the INA. That's not it's not within the scope of this class, but generally speaking, a minor is somebody under the age of 18. So long as they're under the age of 18, it doesn't matter. Now, say somebody comes and stays here past the age of 18, the moment they turn 18, and if they were not inspected or admitted or not authorized to stay in the US, then they begin to accumulate unlawful presence, meaning that if they stay 180 days after their 18th birthday, they're gonna trigger the 3-year bar. If they stay past their 19th birthday, they're gonna trigger the 1-year bar. Asylees, same thing for asylees. Go ahead and read the statute. But an asylee is not only someone that was granted asylum in the US, that also includes somebody that is applying for asylum. So it's very important that you check whether your client has applied for asylum or in the specific date of entry and the specific date they applied, and see if they accumulate the 180 days or 1 year. If they didn't, then that's perfect. Practice pointer, if for some reason you come across a case where a client of yours gets a provisional waiver granted and departs the US, but that person had been here for longer than a year, but they apply for asylum, do a cover letter or a letter explaining to the US Embassy that they did not accumulate unlawful presence as of the day that they qualify for asylum. Be sure to include copies of, for example, the notice to appear, which is a document that indicates the date that they entered the United States, and perhaps a copy of the first page of the asylum application with stamp date on it, just to show that that person did not accumulate lawful presence. Again, if you send somebody out to do their interview at the U.S. Embassy, and they show up, and for some reason they have a different inadmissibility ground other than unlawful presence, they're going to be stuck out there forever. They're going to have to get a different waiver. Family unity, battered women and children, and victims of severe form of trafficking in persons also are exceptions. I don't want to take much time on this any further, so make sure to screen your clients and make sure to actually check whether they even triggered the unlawful presence, the inadmissibility ground. There are situations in which you will find that some people don't even have to get a waiver, and if you don't have to get a waiver, even better. And that's very common for minors and asylees. And there is also the tolling. If they are about to trigger or start to accumulate unlawful presence, but they apply for, say, an extension on their visa, the non-immigrant visa, then they can get a 120-day. However, you have to be, that's what the law says, but realistically speaking, they're not going to get a response or an answer or an approval within 120 days. It's very rare that you get an approval notice within 120 days for anything nowadays. Specifically, I think you have to file the I-539 or something like that. And the USCIS has a website with a report about the processing times, and it's very unlikely that you will get a response before then. You will get a receipt though, and with that receipt, you may be able to help your client with a 120-day tolling. So if they stay past their date, but they applied, keep a copy of that receipt, and if they depart before the 120-day, perhaps they will be able to not accumulate unlawful presence. Next slide, please. So let's talk about the authority to waive the unlawful presence. So what gives the government the right to do that? The INA. The Attorney General has the sole discretion, and make sure that you understand the word discretion. That means that it's not mandatory, to waive clause I, which is the inadmissibility ground, in the case of an immigrant who is the spouse or son or daughter of a United States citizen or of an alien lawfully admitted for permanent residence, if it is established to the satisfaction of the Attorney General that the refusal of admission to such immigrant non-citizen would result in extreme hardship to the citizen or lawfully resident spouse or parent of such alien. So I read it slow because it's very important that you understand this. I've seen it where people make the mistake of just assuming that somebody qualifies for unlawfully for the provisional waiver just because they have a family member that's a US citizen, but that's not the case. The US citizen has to be related to the person applying to the applicant, and they have to have a specific type of relationship. So the the provisional waiver is only granted to the spouses of legal permanent residents or US citizens, and to the parents of US citizens or legal permanent residents. No one else. Many times the most common mistake is that somebody comes to you and they say that they have a child who is a US citizen, the child's under the age of 21 or 18, and they say that they need a waiver because if they don't get their waiver, their children are going to suffer extreme hardship. They don't qualify for that. You have to make sure they have the correct relationship, and we call it a qualifying relative, the qualifying relationship. Second, an applicant for an immigrant visa who is inadmissible under INA section 212A of the INA, which includes the unlawful presence, may apply for the related waiver by filing the form designated by USCIS. And in accordance with instructions, certain immigrants may apply for a provisional unlawful presence waiver of inadmissibility as specified in 8 CFR 212.7E. Basically, what they're telling you is that you have to go to the form itself. You can download it from the USCIS website. You can read the instructions there, and it walks you through. It tells you what the standard. It gives you the form has the information that you need, and they give you a list of possible things that you can submit so that you can prove that they qualify for the waiver. Next slide, please. So the general eligibility. This is from the INA again in the CFR. The applicant, non-citizen, is present in the United States at the time of filing the application for a provisional unlawful presence waiver. So they have to be in the US. The applicant has to be in the United States. Second, the applicant provides biometrics to USCIS at a location in the US designated by USCIS. Again, once you file the application for the provisional waiver, the USCIS will send your client a notice for the biometrics that they have to do. Third, the applicant would be inadmissible under section 212A9BI of the INA upon departure from the US. That is a 3 and 10-year bar. Number 4, the applicant has a case pending with the Department of State with fees paid of an approved visa petition or selection in a visa diversity program. What does that mean? Let's walk back a little bit. Before you apply for the provisional waiver, the qualifying relative or the US citizen or legal permanent resident must file an application for your client. And that is a petition for a relative. It's called a petition for alien relative, I believe, on form I-130. So that's basically the application or the petition where they show that they are US citizens or legal permanent residents and that they have a bona fide relationship to the applicant. And this process is done before you apply for the provisional waiver again. How do you show that the case is pending with the Department of State? Once the petition for the alien for the relative is approved, the case is forwarded to the Department of State. The Department of State is the agency that issues the immigrant and non-immigrant visas at the U.S. Embassy. But before it gets there, once the I-130 is approved, then it goes to the National Visa Center. The National Visa Center will ask you for further documentation before transferring the case to the Department of State. But once you are finished successfully with the petition and the National Visa Center process, then it's forwarded to the Department of State and they open a case. Once they receive the case, then you have to log into some website that they have that they change routinely and pay the fees. And you have to print those receipts and also include them with your application. So that's what they mean by that they have a case pending. To show that it's pending, you have to send those receipts with the packet. Fifth, the applicant will depart from the US to obtain an immigrant visa. That's a no-brainer, that's a requirement. Although I do believe that once you have 1 through 4 completed, your client can go at any time to their country and wait for their appointment there. And 6, and meet the requirements of section 212A9B of the INA. What is that? Can you please go back one slide, Jhon? That is this, that they qualify for that, meaning that the Attorney General in its discretion can waive the inadmissibility ground if they demonstrate that the qualifying relative will suffer extreme hardship. Please note that this is extreme hardship. There are other standards in other contexts. For For example, and Jhon will talk about this in a minute, the cancellation of removal. That requires extreme and unusual hardship. It's different. It's different, and he'll explain that a little bit more. So they have to make sure that they demonstrate that their qualifying relative will suffer extreme hardship. Now, why is it called provisional waiver? Like, the law doesn't talk about a provisional waiver anywhere in here. Well, this is the quick history behind this. Before, in order to process the provisional waiver, the non-citizen has to file an application, and the application may take a while to be processed. And before then, a long time ago, I believe they would have to apply for this provisional waiver outside of the US. But when you leave the United States and you're the United States citizen or legal permanent resident, is going to suffer if that person is separated from, if they're separated from each other. Then what's the point of sending them out of the country and knowing who knows how long they're going to be out there? So what USCIS did is that to avoid family separation, they created the provisional waiver, meaning that they're going to allow that person to apply for that waiver within the United States, and then after it's approved, then they can leave. So that avoids the separation, so they don't have to wait outside the United States for the approval. So that was the whole point. The law doesn't say anything about a provisional waiver, whether it's here or there, but the law does say that the Attorney General is able to promulgate regulations as to how they're going to implement the waivers. So that's what the Attorney General did. That's what the agency did, and they promulgated those regulations to permit people to travel to do the provisional waiver within the United States, and once it's approved, continue with the process outside of the United States. The fastest I've seen personally for my cases, when I get the provisional waiver, somebody had to wait outside the US about 3 weeks, which is nothing compared to the length of time that it takes nowadays to get an approval for a provisional waiver. The provisional waiver, if I check the reports correctly, take anywhere from 8 to 12 months. So if they had to wait outside of the United States, that means they would have to be separated from their families for about a year. And that goes contrary to the intent of Congress here, because the purpose was clearly to make sure that they are able to live in the United States with their family members to avoid the hardship. And if you separate them for that length of time, you're not avoiding the hardship, you're causing the hardship. Next slide, please. Next, again, thank you, Jhon. So the forms, this is my last slide, and then Jhon will take over. But this is the basic forms that you're going to be doing. First of all, it is customary for immigration lawyers to always do a FOIA. Your client will tell you many times that they haven't had any contact with USCIS or with ICE or CBP, et cetera, but it's just customary to do it. Just go ahead and do it. If the US government doesn't really have anything in your client, they'll tell you immediately. Once they match the information that you provide on your FOIA, you will get a response fairly quickly if they don't have any records. If they have records and they're not in removal proceedings, the FOIA can take about anywhere from 30 days to maybe 180 days nowadays. Sometimes they're faster, sometimes they're slower. I don't know what that's based on, but they have different tracks, and you need to make sure that you know whether your client is in a specific track. And they belong, for example, in track 3, which is the fastest one if they are in removal proceedings. Otherwise, you still have to wait like everybody else. G28 and E28. What are those forms? Those are the basic forms to inform the government that you're representing such person. And so the G28 is basically your notice to the government, to the USCIS specific agency, that they are your clients. And the E28 is the same thing, except that you're informing the EOIR that you represented that specific person. And the I-601A waiver, I think you skipped the slide, Jhon. Thank you. So the last thing is the form itself, the I-601A. You can just Google it and make sure you go to the USCIS website. And in there, you can download the form and read instructions and fill the form accordingly. And so those are going to be your basic 3 forms that you need to be aware of when you're representing a client with an inadmissibility ground of unlawful presence and the provisional waiver. Jhon, thank you.
Good evening, everybody. I hope everybody can hear me okay. I don't have my headphones in. But my name is Jhon Tesoro, and tonight my goal is to go over some of the nuts and bolts of the waiver with a focus on the extreme hardship requirement. So in short, my hope is to give a little bit of clarity to what extreme hardship is and how to move it, or how to prove it rather. So before that, I just wanted to go over the 2 scenarios where the waiver is helpful. So the first is obviously the traditional use of the waiver. It's when you are adjusting status but are inadmissible due to unlawful presence. So that's typically what applicants use it for, which Jose discussed in length. But the second one is you could also use it as a tool in removal proceedings. Where the waiver can be the basis to pausing your proceedings to pursue adjustment, which in turn, adjustment is a defense to removal. So the reason why we also called it return to basics is that in 2018, the use of the provisional waiver was prohibited by a BIA case called Castro 2. So recently, that was overturned, and now the mechanism of what we call administrative closure is back. So now we can use the provisional waiver as a basis to pause proceedings and hopefully pursue adjustment, which in turn will be a defense to your removal. So just a little insight on the ways that you could use the waiver. So going to the actual heart of the matter, which is the extreme hardship, right? So extreme hardship is not defined by the INA, and case law has not specifically defined it. But the general rule that I generally use is that the applicant must demonstrate that the denial of the waiver would result in a degree of hardship beyond that typically associated with family separation or relocation. So I know this is kind of weird because there's a vague term and I kind of used a vague definition. So, but this open-ended definition can be used to our advantage, right? So when I read this, my instinct as an attorney is to throw in the kitchen sink, right? Because it says would result beyond that of a typically associated and with family separation and relocation. So yeah, so you do want to throw in the kitchen sink, but you strategically want to throw the kitchen sink. What does that mean strategically? So what I mean by that is organize your hardships according to the hardships that USCIS, which is the agency that's going to be adjudicating your application, and they have explicitly highlighted certain hardships that they look for. So remember that, you know, those are that's gonna be your best guide, is the actual guidance and the actual policies that USCIS has distributed. So, but also remember that the hardships to the qualifying relative will be the only ones considered. But also don't forget that you can add vicarious hardship. So what does that mean? So I think Jose went over the qualifying relative that you can use, which is only a spouse or a parent of your applicant. So in effect, the children of your applicant, their hardships are not, they don't qualify as extreme hardships with regard to the eligibility. But you can use the hardships that are sustained by those children and imputing those hardships to the qualifying relative, which is maybe the spouse or the mother of your qualifying relative. So don't forget about vicarious hardship. So this slide is kind of keeping intact with what I was talking about, the strategy of organizing your hardships. So generally an applicant may show that the hardship to, extreme hardship to a qualifying relative would result from both separation and relocation. But the applicant doesn't have to show extreme hardship under both scenarios, right? So just for definition's sake, the hardship associated with separation is when the qualifying relative remains in the United States separated from the applicant who is denied admission. And relocation, hardship associated relocation is when the qualifying relative moves to the country of origin and the applicant is, when the applicant is denied admission. So basically what this slide, I wanted to illustrate with this slide is, you might have a client that says, look, I'm not gonna go back to my spouse's home country, I'm gonna stay here. But you have really great evidence showing hardships if she would, he or she would relocate. You don't have to waste that hardship, right? So use that hardship evidence that you have for relocation and frame it as a hypothetical. So in your application or your declaration, you would say, yes, these are the hardships that I would sustain if I'm separated, but also if I relocate, this is also the hardships that I would sustain. So don't waste any of your hardships that you might be able to identify. So I know that I said that hardships aren't really, the extreme hardship definition isn't defined by statute or in case law, but as Jose mentioned, that there are hints in the regulations to understand or kind of elicit some type of clues of what the adjudicator is looking for. And that's found in 8 CFR section 1240.58. So the federal courts and the BIA have frequently relied on this statute when deciding cases, when interpreting extreme hardship in the suspension of deportation application. So that does not have the same standard, which is extreme and unusual hardship, but the elements that they mention in those cases do illuminate some of the hardships that are that you can use in your application. The other source of guidance, which is probably one of the most important, is the instructions in the form itself and the USCIS policy on their website. I think it's like chapter 5 when they talk about hardships. So these are what I was talking about when I mentioned that USCIS, which is adjudicating your application, has already highlighted hardships that they look for. So when you're listing out your hardships, you want to keep these highlighted hardships in mind, because that's how you should present your hardship, right? So this slide kind of just goes over a list found in that statute that I mentioned. And these are the types of hardships that you should look for and present in your application. So age, and I hate to read off lists, but we're gonna have to read it off. So age, that means that, what about age, right? So what they mean by that is, think of a qualifying relative that is really young, or on the other extreme, really old. You're gonna have more hardships, either in the context of separation or relocation, if you're really young or really old. And the others are, the ability to speak the language, and adjusting to life in the home country, the health condition, and the availability of required medical treatment in that home country, the qualifying relative's employment prospects in the country which the alien would return to, the existence of family members who will remain in the United States that they might be also separated from, which is going back to the vicarious hardships that we talked about, the financial impact of that applicant's departure, et cetera, et cetera. So these are just kind of, your starting points to when you're trying to look for or list out or present hardships. And this is coming from the regulation. But again, more importantly, you should be looking at the USCIS policy manual, because they do lay it out for you quite nicely. And this is probably how you want to organize or in your presentation of hardships and when you are collecting evidence to show these hardships. So the main tenets are going to be, the family ties and their impact when it comes to separation and when it comes to relocation, the social and cultural impacts that the qualifying relative will face, the economic impact, of course, the health condition and care of your qualifying relative, the country conditions. What that means is that, let's say you have a applicant whose return country has really horrible country conditions. There's high crime, there is a high probability of, let's say, not getting enough medical care, etc. So those are the country conditions that you want to print out and present in your evidence. And of course, there are special factors, like if your qualifying relative is an asylee, they will look at that, the disability and military service of your qualifying relative as well. So what about showing this? So this slide is basically what you can utilize in proving your extreme hardships. Declarations from, obviously declarations from your qualifying relatives, affidavits that kind of support those declarations. For example, if you are a qualifying relative that solely relies on your applicant for, let's say, emotional support or financial support, and you have an affidavit from your mother kind of supporting that and collaborating that. So you might want to gather those. Expert opinions, if you have, for example, a rare disease that requires special care, you want to get letters and opinions from doctors to prove that up, the evidence of employment, things like that. So, and these are just ideas of what you can gather, and just so you could prove up and corroborate your extreme hardships. So the last thing that I wanted to go over that's kind of overlooked is that you still have to, once you prove extreme hardship, you still have to establish that either applicant warrants a favorable exercise of discretion. So what does that mean? Basically, you have to prove that they're a good person and that they're deserving of this relief, right? So you could prove this up by simply, submitting declarations from friends and family saying that, explaining that, this is a family man and he takes care of the qualifying relative, and he has shown kind of interest in helping these folks out. Letters from employers, I've used a lot of these, explaining that they have been a long-term employee and a good employee. Letters from your religious leaders oftentimes are available, and tax returns just showing that you pay taxes and that you are a good citizen, and any awards that you might have gotten or what your applicant might have gotten, things of that nature. So I have a little hypo here, which is going to be a little weird because there's not really a chance for interaction, but let's go over this so you could kind of get your palate wet when thinking about these applications. So Marvin, who is 31, and his mother are from Brazil. Her name is Nasa. So Nasa entered the United States without being inspected or paroled, on the advice of her sister, who promised to petition her. True to her promise, Nasa sister filed the I-130, which was approved, and based on bad advice that she got from a notario, Nasa filed an adjustment of an application for an adjustment of status after 9 years of being in the United States, following her visa being available. The application was denied, and Nasa, unfortunately, was served a valid NTA shortly thereafter. So for those folks who don't know, an NTA is what we call a notice to appear. Basically, it is the document, if it is valid, starts your removal proceedings. So she comes to your office and you determine that NASA does not meet the requirements for asylum, nor cancellation or removal for non-LPRs. But you find out that Marvin, her son, who is a US citizen, is recovering from cancer and is being cared for by his mother, Marvin's maternal grandparents, and has been tragically died in a car accident. So she desperately needs his mother to care for him. And in going through this, you contact your the DHS attorney who's assigned to the case, and he or she says, you know what, I am open to filing a joint motion to administratively close your case if you could find collateral relief. So in your mind as an attorney, you're like, okay, great, I could file an adjustment, and I could adjust him if I could file a 601A waiver. So what's wrong with this analysis? So I'm just gonna go straight to the punchline. You don't have a qualifying relative here, right? Because the qualifying relative that you may have identified as Marvin, but we all kind of berated this point that only spouses and parents are going to be eligible to become the qualifying relative. So this is just kind of a long-winded way of proving a point, which is, yes, the extreme hardship and all these great facts of him having cancer and somebody dying in a car accident. Don't be in a rush to file a 601A. You have to really, really comb through the requirements and making sure you understand each requirement, and you have to meet them before you could start the other part of your analysis. So the reason why I put this hypo, because 7 years in practice and I'm still guilty of jumping the gun and getting excited from the facts of a case rather than the nuts and bolts or the kind of like the basics of what I'm trying to do. So learn from my mistake. So the last slide is just going to be probably one of the more useful slides of this presentation, and it's the application checklist, right? Everybody loves a checklist, and so here is one that we put together for you all. And I think the one that that was included in the materials was another checklist which had frequently missed items on the application. So pay attention to that, because from my experience and other people's experience, these are the most likely missed items on the actual 601A form that results in a RFE, which is a request for evidence. And for all those immigration attorneys out there, the most horrible thing you can find in your mailbox is an RFE, because it delays your your application. So it is worth looking through that to make sure that you have completed those sections, because these are the more frequent ones that result in an RFE. And then, yeah, so that's it for me, guys. I'm trying to get everybody to get out of here and eat dinner. So I'm gonna check the chat to see if there's any questions, and then maybe me and Jose, can you see the questions on your end if you want to take a look? And
Yes, I can see them, and I can take the questions if you want me to. Is that okay?
Okay, I could take I could take one. You could take. There's only two, so.
Yes. Okay, you can take the first one then.
Okay, so let me see. So can I ask via email if they have an immigration record and is this in, so Carmen, is this with regards to a FOIA? Okay, while she's typing, maybe you could take the second question, Jose.
Sure thing. The second question says, should a low-income client whose petitioner husband is relying on public benefits apply for this waiver? I believe there is a little bit of confusion, because remember, as I said earlier, you have to make sure that your client is not inadmissible under other inadmissibility grounds. And I think there is a danger that they may be found inadmissible for being a public charge many times. But you have to remember, the focus is on the applicant. So even if the petitioner, which is the qualifying relative sometimes, like the US citizen, is relying on public benefits, that doesn't necessarily mean that the applicant for the provisional waiver will be relying on public benefits. So let me give you an example. You have a U.S. citizen spouse who petitioned for his or her husband or spouse, let's keep it gender neutral, and that the U.S. citizen heavily relies on the non-citizen for financial support, right? It doesn't mean, and then you do the provisional waiver, and then one of the arguments that you're making for your client is that if the provisional waiver is denied, the U.S. citizen will suffer financially. And so, you know, maybe that will trigger some bells in your brain or some ideas that the public benefits, the public charge and admissibility ground is going to be triggered. Well, not necessarily, because remember, the inadmissibility grounds apply to the non-citizen. They don't apply to the U.S. citizen or the legal permanent resident. Well, they do apply to a legal permanent resident, I misspoke, but even if they are, so that's dangerous for the, I suppose, for the legal permanent resident, but like the analysis is not on that person though. The analysis at the U.S. Embassy or consulate will be on the applicant as to whether that specific person is going to be likely to be, it's likely to be a public charge. So if you made the argument that that person is in quite the opposite, is actually financially assisting the U.S. citizen, already you have an argument to make that that person is actually going to help and it's not going to be a public charge. So I would to answer your question, I don't know if this will answer it, I would say, yes, the low-income client, if you're talking about the citizen, if I don't know if I made the point clear, if the U.S. citizen is the one that's relying on public benefits, no problem. If the low-income client is the applicant and is relying on public benefits, then it might be an issue as a public charge. So I would suggest that you are careful with those and consult with us or someone with more experience to see if we can present it in a way that's not going to be a problem. Now, when you're doing the applications themselves, and when you're doing the petition for alien relative, and when you're doing the application for provisional waiver, nowhere in those questions they ask you about whether that person, the applicant, is likely to be a public charge. But when you fill out maybe other forms like the DS-260, they may be asking you questions about that. I cannot recall myself right now if they specifically ask you whether you've received public benefits, and I don't think they do. Would they ask that question at the interview? They might. So it may be important to meet with your client and go over that. Maybe a good idea would be to get them off public benefits before they go and to demonstrate that they are financially stable at that point. So yeah, so I hope that answered your question, Carmen. And again, if the petitioner is, or the applicant is relying on public benefits, then it's something that needs to be discussed before they leave for their appointment to the U.S. Embassy.
Okay, so I think, yeah, Carmen did clarify that she was referring to the FOIA. So yes, you can't email them if they have an immigration record. I think so on the FOIA record itself, you can indicate that they're in proceedings, and you do go on a faster track in getting your response back. So that is an option that you could put. And just a little insider news is that the FOIAs, if, for example, when I was at DHS, I didn't actually see the FOIA form itself, but if they were in proceedings and I have the A file, that particular request would come to my desk, and I would have theoretically 30 days to respond to that. So it is a quick turnaround if they are in proceedings and you indicate that, because that goes to a fast track. And so what happens is, you mark that this person is in proceedings, and this is the reason why you're asking for the record. It goes straight to the ACC or the DHS attorney right straight away, and they're the ones that basically respond to your FOIA request. So it does help to indicate on the actual FOIA, the request form, which is this, I believe G639, if I'm not mistaken, to indicate that they are in immigration proceedings, and there is a box that asks you, your reason for asking for this record, and it does help to say, in immigration proceedings, preparing for, I don't know, for something, like a master calendar hearing or something of that nature. And the attorney at the DHS office will see that. They won't see the whole form, but they will see it indicated that this is a fast track case, and it is their job to respond in the allotted 30 days, I believe. So it does help. Emailing them after you filed the G639, I don't think might not help, because at that point, the email is not going to get to the right attorney, I guarantee you. So definitely do it on the form if you can, and it'll get you a faster response.
And also, just to be clear, when they don't have a record of your client, they will respond quickly. You will get a standard response on a letterhead saying, we can't find this person. And I mentioned that it was customary to ask for that. At this point, once you are doing the I-601A waiver, the provisional waiver, by then you should have the FOIAs, because the process, the provisional waiver starts with the family petition. When you do the family petition, which right now takes about a year to be processed, you should be doing the G639 immediately with that. Now, if your client shows up just to be helped with the provisional waiver, and that wasn't done by the previous attorney or the client, and they don't have a FOIA, then yeah, it may take a little bit longer if they have records, if they have had contact with CBP, ICE, or the EOIR, and so, or USCIS. So, like Jhon said, if they're in removal proceedings, it's faster, but if they're not, it can take up to 180 days, which you could probably get started doing the I-601A waiver if your client tells you, very confidently they have no contact. But even then, you should do the I-601A waiver. And if something comes back, then you probably should talk to your client and sort of stop the process if there is any information on the file or on the record that may impact the outcome of the case, and that obviously needs to be thoroughly discussed with the client. The other thing that I wanted to touch a little bit on was that Jhon was saying was like, why is it titled the revival of the 601A? To be more specific, he mentioned Castro Tum, I don't know how to say it anymore, but that's been vacated. And what was happening before is that there were regulations that specifically indicated that when a person was in removal proceedings, the provisional waiver was still available for them. And the regulations themselves directed the DHS to work with the respondent or opposing counsel to administratively close the case. They were to assist. The regulations went as far as to tell them that they should, actively or affirmatively help if they believe that person qualified for the provisional waiver. So what they would do is that they would have to agree to administratively close the case. And why was that important? Because when you filed the provisional waiver with USCIS, part of the packet was the order from the immigration judge indicating that the case was administratively closed. Well, then, Attorney General Sessions was appointed, and we all know that they were not immigrant friendly. So what they did is that he decided matter of Castro Tum, where it said, like, the immigration judges do not have the authority to administratively close cases, that their job was to expeditiously enforce the law and determine removability or inadmissibility right away. So based on that, and to a certain extent, the INA, when you read INA 240, doesn't say and doesn't talk about administrative closure or anything similar, or prosecutorial discretion, and none of that. All it says is that the immigration judge shall conduct removal proceedings to determine the inadmissibility or deportability of a non-citizen. So based on that language, they decided matter of Castro Tum, And after that, it was nearly impossible to obtain an order stating that the case was administratively closed. So we were prevented from filing the 601A waivers. So during the time that President Trump was president, I was not able to file those provisional waivers because I didn't have that order. I heard of some lawyers that they were filing the packet with what they call a status docket sort of order. So what the EOIR did after the Attorney General said that they could not administratively close cases, they would set cases on a docket, on a status docket, which was basically the same thing because that would pause the hearings, but it wasn't titled the same thing. So I don't know if USCIS was accepting those or not. I never had the opportunity to do that because things were moving so slow. So on top of not administratively closing the cases, everything was taking forever and is still taking forever. Now due to the pandemic mostly, but before, like, it just seems like there was like an invisible wall to not approve any waivers or anything similar. So in reality, this provisional waiver, while somebody was in removal proceeding, was not a viable option. So I would be forced to just look for different options for the client. But now that we have the new Attorney General, he vacated that Castro Tom and indicated that the things will be the same again. So I actually don't have time to like litigate everything with them. But like if the regulation specifically said that the administrative closure existed, I simply never understood why the Attorney General said that it just couldn't. So it went against the same regulations, and I don't think that was ever litigated because there wasn't enough time for this to reach the circuit courts, the Ninth Circuit. And I don't think there's case law specifically talks about the status docket because that was just a new thing. And so that's why we decided to this class, because now it's an option again. Now that administrative closure is back in place. And in fact, I've already received 2 orders from judges administratively closing the cases, and we're moving forward with the provisional waivers. Jhon, do you have anything to add?
No, I just had one quick practice pointer that somebody brought up, is that on your FOIAs, you have to make sure that you have your date of births correctly and the spelling correctly, because a lot of times you will get a no response or no record, but because you put the wrong birth date, and that's why you're getting that. So again, the details is very important when it comes to these forms, and just kind of watch out for those little typos and things like that, because you might be like, thinking that you're all good and you don't have a record, but you do. So just a little practice pointer.
Do we have any further questions about anything? We have time.
Okay.
No questions. Well, then that shall conclude the presentation. If you have questions that come to your mind later on, do contact us. My email is jose@josemarinlaw.com. And Jhon, if you want to give me your email.
Yeah, mine is very easy too, Jhon@tesorolaw.com, but my Jhon is spelled a little differently. It's Jhon, so just be careful. So Jhon@tesorolaw.com, and I'd be happy to I don't know, talk about your case.
And remember, you can also Google our names. We're the only Jhon Tesoro and Jose Marin that are lawyers in California. Well, there is another lawyer in California called Jose M. Marin, but he's a public defender, and you don't want to contact him. You want to contact me for this.
And I just want to give a
Go ahead.
No, I just want to say hi to Melanie and Ryan and Rachel that I see. I don't know, give them a quick shout out.
Let me just do a quick wrap up and stop the recording, and then we can chat a little bit. I'm going to put the evaluation in the chat. I want to thank the HIV Legal Services Fund of the American Bar Association HIV AIDS Impact Project, California attorneys, make sure to complete the survey to receive CLE credit. I put it in the chat. When you close out of Zoom, it should appear. You'll also get an email. Some people joined by phone. So if you didn't get it, if you don't get it, please email mcle@alrp.org and I can send the evaluation that way. And then shortly after we receive your evaluation, you'll get your CLE credit. And if you're watching on CLE Hero, there's also an evaluation and you can get credit that way. So that concludes our presentation.